Welcome to the PI show, Melbourne's only show about personal injuries. In fact, probably Australia's only show, and dare I might say, perhaps in the world. I'm with Martin Smith and Tony Carbone, and we're three lawyers who are very passionate about personal injuries and discussing all the issues arising from people who are injured in any circumstance. In Victoria, in civil matters, in injury matters, we have what's known as a jury.
Correct.
And a jury is a very old institution, inherited from England. I think we've all been involved in jury trials.
Yes.
And I think people are fascinated by juries. There's just an inherent drama about juries. And tonight we're discussing juries. The first question is, who decides whether a trial proceeds before a judge or a judge and jury?
Right, in the two courts that basically deal with personal injury claims in Victoria, you've got the County Court and you've got the Supreme Court. To get a case before those courts, you issue a writ, and both the plaintiff and the defendant have a role to play, I should say. That is that the plaintiff can ask for a trial before judge alone, or alternatively a judge and jury. If they ask for a judge alone, the defendant, when they put in their defence or their appearance, have also got the right or the ability to ask for a judge, and they serve what's called a jury notice.
So either
the parties decide.
Either the parties decide.
Yep, the parties decide.
And if you're a plaintiff lawyer, do you choose to go before a judge or a judge and jury?
Well, more often than not, you'd probably go before a judge, Harry, because judges have to give reasons, and they're a lot easier to appeal if the decision's not to your liking. And if you're a jury, it's a lot harder to appeal a decision because they don't give reasons. So as a rule, in this day and age, plaintiffs generally go with judges alone.
Judge alone. Yeah. And what about defendants? What do they do?
Oh, if there's going to be issues of credibility, and I would have thought that the defendants can put up a jury notice to say that the person will be not only judged by a judge but also by their peers. Those peers are people that come out of a jury pool.
So Martin, you're saying juries are more prejudiced?
No, not at all. I'm saying that it's an
issues.
alternative method of trial, and as I think you said, that it's a situation where some plaintiffs may be served better before a judge, some may be served better before a jury.
If you've got someone for catastrophic injury, sorry, Harry.
Yeah,
someone
I was going to raise
catastrophic injury, what would you select then, Marty? You as a plaintiff lawyer.
Is liability an issue?
Oh, yeah, it is an issue.
Look, there's issues of sympathy, there's issues of
common sense?
Common sense, yes. There's issues of fact. The judge in a judge and jury trial, the fact deciders are the jury.
Yeah.
So catastrophic injury.
I think catastrophic injury, and there's no issue about liability. Someone's a passenger in a motor car, so let's say liability is not an issue. Catastrophic injury, the only issue is damages. Then there's complicated history. You might decide before, have the case decided before a jury.
Look, I'd probably take a judge, Harry. I'd still take a judge.
I'd possibly choose a jury in some cases. So let's say one of the parties has decided on a jury, and then you're there in court on the first day of a trial. What happens and how's the jury selected?
Well, first things first, the jury won't be called unless the jury fees have been paid. If the jury fees have been paid, then they call 12 people in the room to stand before the court, and both sides then have an ability to challenge as each person stands forward and gives their name and their occupation.
They've got to stand up and give their name and occupation.
That's correct.
So that's all they've got to say.
12 names are initially called out.
And they stand up.
And then
they've got to say present.
Yes.
And then they've got to say their occupation. So their occupation might be housewife, retired insurance broker, small business owner. You can't be a lawyer and be on a jury.
That's right. You can't be a doctor and be on a jury. There's a lot of professions that are excluded.
Yeah.
Yes.
Yeah.
I think nurses are excluded as well, so it takes a lot of people out of the system.
So 12 people get up, give their name and occupation, and some of them say, look, I'm terribly sorry, I can't. The judge says this trial's going to go for 10 days, and someone says, Your Honour, I can't afford 10 days. What happens then?
Well, they're sworn in and they're asked questions about why, and you'll find that the judges are pretty sympathetic to their needs.
So people can be excused from jury duty?
Yes. They could be running their own business, Harry, and they can't afford the 10 days.
Might be a mother at home with 3 young children. It's inappropriate for her to be away from them for 3 weeks. Or 3 days. It can be a person in poor health. It can be a person running their own business. There are a number of reasons and hardships that'll exclude somebody from a trial.
So the judge has the final say in whether they are excused or not. Some judges might say, look, that's not a sufficient enough excuse, and you're not excused.
That's correct.
So they're 12 people, and then each party in court.
You get to strike off 3 names. So you've got the plaintiff and the defendant, you strike off 3 names each.
And how do you choose the 3 names?
There's a skill in selecting a jury. Obviously, when you think of who the plaintiff is, if the plaintiff, for example, is, let's use an example, a farmer. Well, if you're in a farming district, those people may understand what he has to do each day.
Well, let's assume we're talking about Melbourne, Martin, where they don't know each other. So effectively, you're more at large.
Yes.
So, you've got a farmer in Melbourne, what would you do?
Well, it may be a situation where they're talking about economic loss, and all of a sudden you find that one of the persons on the jury is a banker. He'll understand facts and figures pretty quickly.
Retired bank manager.
Yes.
So they might understand economic loss.
Yes.
And you might tick that person and say, we want that person on the jury.
Yes.
And the other side might say, no, we're going to cross that name off. Yep. So at the end of that process, there's only 6 names left.
There's 6 names left.
So the jury is then impanelled.
Correct.
They're sworn, and they take their seat in court.
And then they have to nominate a jury foreman or forelady.
Forelady.
Yep.
And they're given a pen and paper.
Yep.
And then the judge explains to them their role in the trial.
That's correct.
All right, well, that's all we've got time for. We're going to come back and talk about the how a jury trial unfolds in practice. We'll be back after the break.